certainly have fears that there is a serial killer at loose in Perth.
Sarah Spears, Jane Rimmer, Ciara Glennon.
And every time you saw a young girl walking by, you think, oh God, is she going to be the next victim?
Now, one man stands accused.
If police are right and Edwards is the Claremont serial killer, he's been hiding in plain sight for 20 years.
The judge deciding the fate of Bradley Edwards today banned anyone inside the court from revealing distressing details of Jane Rimmer and Ciara Glennon's post-mortems. Welcome to day 31 of Claremont in Conversation. Natalie Bongiolo joining you with Tim Clark and forensic scientist Brendan Chapman. Tim, can you explain what this suppression order means?
Hi Nat. Well, yes I can. So off the top of the proceedings this morning, Karin Margolius, the prosecutor, got to her feet and told the judge that she wanted to raise something, and that something was that overnight there had been discussions and submissions made to her, chiefly by the families of Ciara Glennon and Jane Rimmer, outlining their concerns that of what was to follow today, which was evidence chiefly from pathologist Karin Margolius via the statements that she'd made, and then from Clive Cook in person. The body of that evidence was to be all the details from the post-mortems of both Ciara and Jane. And Ms. Margolius said that the minutiae of those and the real detail of those had been basically kept from the families for their own well-being, out of a sense of sensitivity, for the duration, basically since 1996 and 1997. And the families had no wish to come across those details that had been kept from them via the media. Well, that was their wish anyway. And so Ms. Margolius raised that with the judge this morning. Justice Stephen Hall gave the reasons for it and asked for a temporary suppression order to be put in place for the duration of the evidence, which I think is going to go into next week, or we know is going into next week, so that all that evidence can be heard in a block by Justice Hall, and then he could maybe make a ruling at the end of all that evidence as to what he thinks should be let into the public domain, is in the public interest, while striking a balance to protect the sensitivities of the families of Jane and Ciara. And so that is what Justice Hall did. He made that temporary suppression order on the basis that he will revisit it and can revisit it at his own leisure. And more pertinently for us as media, if as organisations or as a media en masse, we wanted to make a submission to the court about that temporary suppression order, we were well within our rights to do so. And so that was where it was left this morning. So we heard from a couple of witnesses first, and then the pathologist Karin Margolius' various statements were read into evidence at length by Ms. Margolius, and it is those, or the detail of those and the content of those that we are, as it stands tonight, suppressed from reporting and revealing.
Is it an unusual suppression order in any way?
From talking to other to lawyers that represent Seven West Media, which I work for, the media company I work for, and other lawyers that deal in this area, the reasons for the suppression order I've been told are quite unusual in the terms of the only real reason it was brought forward was because of worries by the family about the sensitivity of the material to be voiced. Usually that is a consideration that is taken into account by a judge, but not usually the sole reason for it. But as we've said so many times, this case is unique and extraordinary, and so this is another one of those extraordinary things that has happened in the process.
Brendan, you've been involved in many court cases such as this. Is this something that you've come across before, that details such as this are suppressed, I guess, for sensitivities?
No, this is not something I'm familiar with. I guess given the size of this trial and the enormous public interest, I can see why, but it's certainly not something I've seen before.
Yeah, I mean, I guess none of us can imagine just what the families are going through and this unimaginable horror that they're living through. And as you said, Tim, they're not sitting in court for this particular evidence themselves and don't want to hear it through the media.
Correct. They were warned or forewarned of what was likely to come at some stage this week, and were gently advised that perhaps it wouldn't be in their best interests to be there for it. Not that they'd want to be anyway, I wouldn't have thought, but through some liaison with police officers and people that have been working with them from the court, and certainly they weren't here today, but they did, through Ms. Barbagallo, make their feelings quite clear as to what they would like to happen. But to be fair to us, and the judge, Justice Stephen Hall, was fair to the media, that we were entitled to have a say. He would listen to what we had to say about it going forward, and then he would be very open to hearing what we had to say, and then he would make a final decision, when he feels the time is right, which I'm sure he will do.
I'm curious as to perhaps why this wasn't considered earlier, knowing that this evidence was going to be coming. It's almost a little bit like when the screens were put up, because all of a sudden it was realised that this footage that was too distressing to show to the court needed to be screened. And it seems like we're sort of in this situation again now, even to hear it or for it to be broadcast is too sensitive.
Yeah, it's an interesting point, Nat, and it's one that there are a million moving parts in a trial of this size, obviously, and there are many things that are being done on the run, I suppose, on the fly, decisions being made on an hourly basis on what questions to be asked and what evidence that should be brought. And then there are also outside factors, such as the media, such as family, such as attendees in court, such as security, such as Mr. Edwards' ongoing well-being, I suppose, if you want to put it that way. And these things are all trying to move as one to get the trial to go forward. We believe or understand that as this evidence was coming closer and the detail around it was getting more detailed, if you want, from other witnesses that were being called, that there might have been some extra sensitivities felt by the families, and that might have prompted this submission to via the prosecution today. But as hopefully responsible media outlets, we are well aware of the sensitivities around it. We wanted and continue to want to not get in the way of the judicial process, but be able to report as freely as we possibly can. And so, that is where we found ourselves today, and we were very willing to abide by any order the court makes, obviously, because there are serious ramifications if you don't. The other unusual part of the suppression order was also that it was not just directed at the media, as they usually are. It was specifically and pointedly directed to people that were within the court as well, i.e. members of the public. And they were warned, both verbally and in the order, that it applied to them as well. So they were not to go and just because they had the privilege of hearing this evidence in person, because they'd taken the trouble to go to court, that was always going to be the case, but they were not allowed to broadcast it via any social media channel or even any verbal channel to people who weren't in the court, and the judge made that very clear to anyone who was in the court, and they were left in no uncertain terms as to their responsibilities as well.
So just to make that clear for listeners, that means that, for instance, not only can you not tell us now in this podcast, but you can't walk outside that court and go home and tell a member of your family. No one is to repeat anything said within that court today.
And that goes for me and anyone else who was in there. And there were obviously, as there has been for many, many days, many people. So it applies to them. And the ramifications, the repercussions of breaking an order like that is a potential contempt of court charge, which does bring with it a potential prison sentence. So that's why we take these orders as media seriously, and that's why anyone should take them seriously.
Brendan, the details from a post-mortem are obviously very distressing. How often would family members be privy to some of those finer details?
As forensics, we have less involvement or very minimal involvement with the family. So I can't speak from personal experience, but I certainly do know that the detective family of the victim relationship is a bit like any relationship, I suppose. It depends on situation, and it's a bit of a work in progress as to how that relationship evolves, I suppose. So depending, and I'm assuming here, but depending on how eager the family are for information would probably determine what level of information is fed back to the family. Of course, I'm sure they're entitled to know as much as they want, and if they request that, then by all means, I'm sure they're able to have that information. It really just comes down to how that relationship is managed, I suppose, by the police investigators.
Yeah. Well, Tim, as you mentioned, there were two other witnesses in court today who those details are open to the public. Mm-hmm. And the first was the forensic dentist.
Yes, so he gave evidence in terms of the process of identification of the body. So I'm sure a lot of our listeners would have heard that one method of identification is obviously dental records, because your dental makeup can be, as an adult, as unique as your fingerprint or your DNA, and so that was the process that was gone through. That the Glennon family doctor came in as part of that identification process with a periodontist who specialised in that procedure, and he described how that was done, basically. And even then, we were told of sensitivities around that procedure, given that the dentist that was involved in bringing in the dental records of Ms. Glennon was shielded somewhat from the entirety of her remains, because the periodontist who was giving evidence said, we realised that might be psychologically harmful to him, given that he had a long-standing medical relationship with the family, and so the remains themselves were shielded as much as possible apart from the mouth and the teeth, so that inspection could take place and formal identification could take place after it.
Brendan, is that the usual process, that a forensic dentist would then need to call in a family dentist to look at the results?
Yeah, just like most things in forensics, we have a sample that we're comparing to another sample or a reference. And in the case of dental records, these are hugely detailed documents that are kept by dental practices. They regularly X-ray, and their notes are really quite unique in being able to assist the forensic odontologist to make that identification. So without that, he's really just looking at a set of teeth without having a comparison point in order to then say, okay, this matches the comparison point. The other thing or the other benefit of having these documents maintained by dental practices are that they have, largely very thorough and well documented notes, and they're well characterised by patient details and everything. So they're quite a good source of information.
Brendan, is this usually the way that a body is identified?
Yeah, there's three kind of gold standard identification techniques that we use in forensics, and they are forensic odontology or dentistry, fingerprint comparison, and DNA. Now, fingerprint comparisons and odontology can both be achieved quite quickly, so they're usually the first pass in establishing an identification of a body. This is assuming someone can't visually identify a loved one or a family member. DNA kind of plays second fiddle to those two because it takes a little bit longer, and ultimately it's a bit more of a costly exercise as well, so very normal.
So this is another person who's in the post-mortem. Tim, was the dentist quizzed on what he was wearing and how he arrived, and if he could have possibly transferred, any fibres or cross-contamination?
Yeah, I mean, they are becoming standard questions, Nat. So, yes, he was. And he was also shown video of the post-mortem of Ciara as well, and asked questions around her positioning, particularly on the floor, which we discussed earlier, which was done not out of any disrespect, but more out of an ability to get photos that were needed. But yes, they are standard questions that we're very used to, and he did answer them. And there was mention of cars and things that he drove, but at no great length, and to be honest, of no great significance, because it didn't really glean any evidence that might become significant.
You also heard from the state's mortuary manager, and we were meant to hear from him yesterday. Of course, that was postponed. What did he reveal today?
Yes, so this is Anthony White. He is currently the state mortuary manager. He wasn't at the time, but he was on the staff. And again, a hugely experienced mortuary technician. They've all seemed to have been asked the same question: how many post-mortems they've been involved in. His number was 60,000. He estimates over his long and very experienced career. And once again, he was probed about what he particularly did, about techniques used in the mortuary then compared to now. And the one thing that was particularly honed in on was during his attendance at Jane's autopsy. He was asked particularly about his gloves, and this again went to areas of possible contamination. He placed at one point in the video of Jane's autopsy, you could see his gloves placed on the floor and then picked up again, and he was asked what he did with them, whether he put them back on again. He said he honestly and truly couldn't remember. There was some later footage of him wearing another set of gloves. He was asked whether they were the same ones. He said again he honestly couldn't remember. And then at his presence at Ciara's post-mortem the following year, he was again asked for his role, which was simply to do whatever he could at the request of Dr. Margolius to help her in that process. So yeah, it was pretty brief evidence from both those people, but part of the process that needed to be go through, as we've discussed, to basically tick off anyone and everyone who was at those post-mortems to get first-hand evidence of what they did and what they saw and what they possibly could have done that might have put them in contact with the bodies.
When you mentioned the 60,000 post-mortems, it is an extraordinary figure. Brendan, did you know that anyone in the state or in the country would have actually performed that many procedures?
I know Tony's been around the mortuary for a long time, but I never envisaged that sort of number. I'd worked with Tony on a number of PMs, but 60,000, that's quite astonishing.
Yeah, I don't think that's not actual personal involvement, because he becomes, as we heard from Bob McDermott last week, when you become the mortuary manager, you have involvement in the planning of them, the staffing of them, the preparation of them, the documentation of them, all those type of things. So I think that would, rather than in physical involvement, that's what he meant. But it is still a staggering number, and he did mention there could be up to 10, maybe even on a really busy day, 15 post-mortems performed at the State Mortuary, because, as its name suggests, it is the facility for the state of Western Australia, which is a massive geographical area, and certainly the population has grown a lot in the last 20 years as well.
I imagine that if you've been involved in that many procedures, you may be able to answer this, Brendan. Would it be quite difficult to have an independent memory of every single procedure that you've been involved in?
Yeah, it's very much similar to what we're seeing with the crime scene guys, who are relying really heavily on their notes, and that simply just comes down to the fact that they're doing this is their day job. They do it every day, and the notes are in some cases all they have to go back on in order to remember it. Because, I mean, to use 60,000 postmortems as an example, even if that number was, a tenth, it's still a huge amount of postmortems for any one individual to have explicit detail in what they recall from that instance.
Tim, was Mr. White quizzed about protocols back then and procedures?
Yes, briefly, and particularly more a historical context of where DNA technology and knowledge was as at 96 and 97 compared to now, and also in terms of physically how a post-mortem at the State Mortuary is conducted, because we'd heard previously that particularly during Ciara's there might well have even been another body or body bag in the vicinity at that time. He said certainly now that never happens. They are all done on a sort of individual basis, and in terms of DNA technology, I think we're even the most unclued up true crime follower in the public would know that DNA technology, as at 96, 97, was vastly inferior to what it is now in terms of the testing and the understanding of maybe how DNA and certainly trace DNA could be passed on from one person to another.
Did he talk about whether face masks were the norm back then? Because obviously some people have had them on, some people haven't.
Yes, I think that was raised as well. And in general terms, many of the mortuary staff have been asked that, whether it was a standard issue piece of equipment. Many of them said it wasn't, but they were available. But all of them have said the understanding or the issuing of them was not a forensic thing in terms of possible contamination. It was more a self-preservation thing in terms of dealing with matter that might be a contaminant, basically, when you're dealing with sometimes remains that were heavily decomposed, and there was a fear then and now that could possibly possibly lead to some sort of contamination of yourself, and so that's what the masks were there for, rather than to protect any potential evidence.
Brendan, would you say that is there a time when that really did become standard procedure?
I couldn't speak specifically, but I do know that all of the forensic facilities at some point in the history, going back, would have gone through what we call an accreditation, I suppose. And that's where essentially a central body undertakes a review of the processes and kind of gives it their rubber stamp to say that they meet a certain level of quality control. It's similar to, I suppose, what you'd say an Australian standard. In Australia and in forensics, the main authority for that is NATA, which is the National Association of Testing Authorities. I couldn't speak specifically about when those audits or when that accreditation came into forensics in Australia, but it's been ongoing for a number of years.
Okay, well, we have some listener questions for you relating to DNA from Kay Brown. Just wondering if the DNA from all crimes in WA are in a central database, and if not, why?
Yeah, they are, and that's what the legislation that came through in the early 2000s was about. It was about the ability to collect DNA from people charged or convicted of particular offences in WA. And so when we take that DNA, that goes onto both a state and national database. So there's a state database of all the DNA profiles, and there's also a national database of all the DNA profiles. So when DNA is collected from a person or from a crime scene, it's matched between all other samples collected in the country, and even across to New Zealand, I think.
You know, we've seen these sort of TV series where these matches pop up on DNA databases and they've got their guy. Is it like we see on the telly?
It's absolutely not that exciting, I'm afraid. It's not the image of kind of this digital photo, identikit photo that pops up and says, this is the bad guy. And they always look like bad guys too, remember. It's much less interesting. It's much more along the lines of what you would expect to see in reams and reams of Excel sheets, I'm sorry to say.
So it's not even a graph with spikes on or anything, Brendan, that
No.
you can overlay, and that's definitely we've got our man.
No, nothing that interesting, I'm afraid.
Yeah, we did ask you when you were in last week if it was the forensic scientist who would have that eureka moment where they realise they've got the match in front of them.
Yeah, there's certainly, there is, but then you also need to have this element of composure as well, because once you identify a match, of course there's excitement that surrounds that, but then we also have process we need to follow, and that needs to be peer reviewed by another scientist to make sure that our results are correct before we can release it. And I guess it kind of takes the excitement away.
Because you've got to have it double-checked, triple-checked, and so it's a bit like VAR in the football in the UK at the moment. Everyone, when they score a goal, there's the initial joy, and then they've got to look on a screen to make sure that it's going to be ticked off by the powers that be.
Exactly.
Well, I hope that answers that question for the listener. From Sophie, in terms of evidence, Tim mentioned that regarding Bradley Edwards, there is an undeniable series of coincidences, and if we join the dots, could someone please explain the relationship between uncanny coincidence and reasonable doubt? That's for you, I guess, Tim.
Yes, so I think I was talking in the context of Ciara's case being a purely circumstantial case, and what the prosecution are basically arguing is if we can prove that Mr. Edwards was the killer of Ciara via the DNA and the fibre evidence and the other similarities between that case and Jane's case, which also contains physical fibre evidence that they say points to Mr. Edwards, then that should be their argument is, well, you extrapolate that out, and what are the chances that someone who did those things to Ciara and Jane wouldn't have done it to Ciara, and that is their argument, that there is a line between these cases that is undeniable in terms of their similarities, and so if we can prove the from backwards to forwards, if you like, in date time, if we can prove Ciara, prove Jane, then it goes to Ciara, and so that's what I meant by an undeniable series of coincidences and joining the dots. But where reasonable doubt comes in is exactly where reasonable doubt comes in. It's that can, and this is what the defence will argue, can, even if you do find Mr. Edwards guilty of Ciara and of Jane's murders, can you even then still make the jump and say there is no possible other explanation to Ciara's killing other than it has to be Mr. Edwards, and so that is the argument that will be had long and strong towards the end of this case when the closing arguments come. From one side, Ms. Barbagallo says, well, you have to make that leap because there is no other logical conclusion, but Mr. Jovich will say, well, you've got to prove the other two, and then even if you do that, is that leap of faith too far? And I'm sure that's what he will argue, is that yes, it is, because there has to be a doubt, because there is no physical evidence. There is no evidence that Mr. Edwards even came into contact with Ciara, let alone killed her. So those are the arguments that have been made briefly and are yet to be made right at the end of the case when we've heard all the evidence, including, obviously, most importantly, the physical evidence being the DNA and the fibres.
There's another question relating to the evidence. Can the Path West contaminated evidence have any influence, or is it no longer admissible?
Well, that's jumping ahead, because obviously that the question of contamination comes from the defence side. That is their contention that it could be, but there is no evidence to that effect yet, and the prosecution very strongly argue, or have argued in their opening and will argue in the months to come, that it's not contaminated, and so that's why it is in. So that's where all that argument, which we understand will begin in the middle of February, will centre around the prosecution saying, well, there is no contamination. There's no proof of any contamination, and so the only other explanation is that evidence, that DNA evidence, comes from Mr. Edwards during a struggle when Ciara was fighting for her life.
Well, there's been almost 150 witnesses so far, and we know that the next couple now are out of bounds in terms of talking about their evidence, out of respect for the family. Tim, you did allude to this earlier, but will this evidence that's going to be presented over the next couple of days, will that ever be released?
Yeah, so as I said right at the start, now this is a temporary suppression order that Justice Hall has placed on it today. He said he's very open to hearing arguments from all sides as to whether that suppression order should be lifted altogether, whether it should be amended, or whether it should stay in place. As a media organisation, 7 West Media have put in a written submission to the court over the course of the day with our thoughts about this, and my understanding very late, or very just before we started talking today, is that all the parties, prosecution, defence, the judge, the court itself, have received that submission, are going to consider it overnight, and there may be hopefully some more discussion about it in the morning. So my hope is that we, as all parties, can come together and reach some agreement which will lead to us being able to report something of what's been said today we are allowed to say that Dr. Margolius' statements were all read in, and Dr. Clive Cook, who's one of the other forensic pathologists, began giving evidence in person today. My hope is that we will be able to report some of that as far as we can to go to the pertinent points without going into details which might be unreasonably distressing for the families and obviously for other people as well, because this is not normal detail that we would normally report, but as this case is so detailed, and that is the nature of the proceedings. So yes, I think that I think we will be able to report some of it, but at this point I'm not sure how much. But we're being as responsible as we can, and trying to reach a happy medium where reporting informs the public but doesn't distress the families.
And we would like to let listeners know that when the suppression order was handed down today, we did edit yesterday's episode. That was day 30 to fall in line with those wishes. So people might notice there is a cut in there that seems a little out of place. Well, Tim and Brendan, thank you both for your time, and you can email us at claremontpodcast@wanews.com.au. We'll be back tomorrow with Alison and Tim to wrap up week 7 of Claremont in Conversation.
This podcast was produced by Kate Ryan and Alicia Preedy and recorded in the studios of 7 West Media. Audio files were provided from the archives of the 7 Network and the West Australian. Sign up for daily emails and all the latest on the Claremont trial at thewest.com.au.
Enjoying this podcast? If the story behind the headline matters to you, then you can count on thewest.com.au to deliver. For more on Claremont the trial, follow the live blog, watch the nightly news updates, and sign up for daily email updates at thewest.com.au. Subscribe now for just $1 a day at thewest.com.au.